manufacturing jobs and the need for our economy. Well, we now have our committee pitching in because we're manufacturing a crisis. We're manufacturing something that doesn't need to exist and doesn't need to happen. In fact, the reason I know it's a manufactured crisis, I go back to the very words of many on the other side a few years ago, and even my chairman, when they joined a walk-off of the House floor chamber to protest, in his words, the shameful and politically motivated GOP vote holding Eric Holder, Attorney General, in contempt. Walked off, upset, tore up, because they were holding Eric Holder in contempt after almost a year, over a year, 400-plus days, in which accommodations back and forth were made, discussions were made back and forth. So really, we're just manufacturing a crisis because, number one, we didn't get what we want. Number two, we don't like what we got. And there's nothing being hidden here. And yes, the Attorney General is following the regulation. Don't be deceived. He is. It's interesting that we go along, and also that some of the interesting things that's been talked about there. We talk about Nixon impeachment in Article 3, and this has been thrown out by my colleagues. All of the subpoenas issued to President Nixon, and again, a whole different inquiry, which was an impeachment inquiry, were issued after the impeachment inquiry was already started. These were not before the impeachment inquiry, they were after, and that's what we found that. In fact, the impeachment inquiry was opened on October 30th, 1973. All the subpoenas were from April to June of 74. So let's at least get our facts straight. We've had issues, all day today that we've had to sort of correct. Number one being that the chairman now of the Oversight Committee was not sued in his personal capacity. Mr. Flynn is not in jail. He's pled guilty. He is still in that process, but he is not in jail, as was stated earlier. And also, though, I think we've finally come to the conclusion that I think we've all been waiting for, and it was really something interesting to come. And that was that my friend from Georgia actually gave us. And it was really sort of summed up this entire thing. It's what I talked about last week. It's what I talk about now. And my friend from Georgia said, and he brought down the curtain on this entire thing when he said, no documents, how do we impeach? If we don't have the documents, how do we impeach? Because right now, let's be honest, by that very statement, he's making the claim that they don't have enough to impeach because Mueller didn't give them impeachment. The report did not show collusion and did not charge obstruction. There's nothing to impeach. So now we got to dig deeper. And my question is this. An investigation of and I'll agree with my friends across the aisle, from a top-notch investigator, from top-notch attorneys who had unlimited access to a grand jury, unlimited access to subpoenas, unlimited access to investigators, and over $30 million at least in budget, which is larger than any House committee. And we think we're going to find out something more than he found out? Come on, we're manufacturing a crisis, and that's why we're here. And I yield back.
Gentleman yields back. Does any member seek recognition? Gentleman from Maryland is recognized.
Thank you, Madam Chair. Move to strike the last word.
Gentleman is recognized.
Thank you. Madam Chair, Tom Paine said that in the monarchies, the king is law, but in the democracies, the law is king. That is the principle at stake in America today. The President of the United States and all of us who seek and attain public office are nothing but the servants of the people and the servants of the law. And the moment that we forget that and we begin to act like the masters of the people and the masters of the law, then we put our jobs at risk. If the gentleman from Florida is so convinced that the Mueller report offers complete and total exoneration of the president, why doesn't he want the Congress and the American people to see it? Well, he says the Attorney General has only redacted 8% of the report. Madam Chair, you could redact 8% of the Constitution of the United States and get rid of freedom of the speech, freedom of the press, religious freedom, equal protection, and due process. You wouldn't have enough room to get rid of Article 1 of the Constitution, which is, I know, what some would like to do today. But Article 1 is the provision in the Constitution that establishes the powers of Congress, the lawmaking branch, the branch of the people. The president's sole job, primary job after being commander-in-chief, is to take care that the laws are faithfully executed, not circumvented, not defied, and not violated. Now, Madam Chair, I think we need to remark how far this president has lowered our country. First, they destroy the norms and the values of society, things that we'd always taken for granted. You don't mock people with disabilities. Men don't mock women's bodies on television. You don't ridicule people and give them obnoxious nicknames, at least after you graduate from the 3rd grade. You don't falsely accuse other political leaders of treason. You don't accuse other political leaders' parents of assassinating President Kennedy. You don't use disgusting, profane language to disparage other countries, and you don't call neo-Nazis and Klansmen very fine people. You don't give aid and comfort to the dictators of the world, like Kim Jong-un and Vladimir Putin, by flattering them and being their sycophants. But then you destroy the norms and the values of your office. You call the press the enemy of the people. You call true facts fake news, and you call fake news true facts. You vilify and you demonize the hardworking employees of the Department of Justice and the FBI. You accuse them of being part of a fantasy deep state conspiracy just for doing their jobs. You falsely claim that millions of people voted illegally, while you deny and dismiss the finding of Special Counsel Mueller that there was a sweeping and systematic campaign to disrupt our elections in 2016. You refuse to divest yourself of your business interests or to put them in a blind trust, as other presidents have done. You travel to your own business properties and hotels on government expense. You double initiation fees to Mar-a-Lago. You turn the government of the United States into a money-making operation for your family, for your business, and for yourself. And then you violate and undermine the laws of the United States. You sabotage the Affordable Care Act to try to deny millions of people access to their health care. You separate children from their parents at the border. You pull out of the Paris Climate Agreement, making our country an international environmental pariah and outlaw state. You lie about what science has shown about climate change. You call it a Chinese hoax. You collect millions of dollars from foreign princes and kings and governments in violation of Article 1, Section 9, Clause 8 of the Constitution. And now the president, aided and abetted by the Attorney General, tears at the very fabric of our Constitution. He orders that a curtain be pulled down over the executive branch. He says there will be no cooperation with the lawful demands of Congress for information. Congress shouldn't be looking anymore, the President King declares. This is all. It's done. No tax returns, no Mueller report, no witnesses, not Don McGahn, not John Gore. The president declares himself above and beyond the law. The Supreme Court has repeatedly stated that it is an essential and integral aspect of our power under Article 1 to do fact-finding investigations for the people. James Madison said, "Knowledge will forever govern ignorance, and those who mean to be their own governors must arm themselves with the power that knowledge gives." The people, through the Constitution, gave us that power. We must exercise it. If you act with contempt for the people and Congress, we will find you in contempt of the people and of Congress. And I support the resolution. I yield back, Mr. Chairman.
The gentleman yields back. For what purposes does the gentleman from Virginia seek recognition?
Move to strike the last word.
The gentleman is recognized.
Thank you, Mr. Chairman. As I've sat here and listened, it's getting more and more frustrating to me, and I am sure to people watching at home, how distracted this committee is getting from the issues that truly matter to the American people. And we heard Congresswoman Lesko speak to those. When I get home, my constituents want to know, are we addressing the availability of health care and the accessibility of health care after the skyrocketing premiums that came into place from Obamacare? Are we taking action to reform and renew our highway and infrastructure system to keep up with our booming economy? Are we working to stop the wave of illegal immigration flowing across our borders? These are just a handful of issues that we should be working on. We should be looking at ways to reduce government regulations and find ways to put more money back in Americans' pockets. And instead, my colleagues on the other side of the aisle are calling for more and more investigation, pursuit of documents, even those they're not entitled to receive. And without a judicial proceeding, my colleague from California argues that we are entitled to receive it, not without a judicial proceeding. They're in search of a smoking gun of collusion, conspiracy with Russia that does not exist. Volume 1 of the Mueller report shows clearly It does not exist. Some of my colleagues are running for president on that ghost, on that very ghost, that somehow collusion with Russia still exists somewhere. This report proves there was no conspiracy. I was interviewed a while back, and I said, I hope that as much as possible is released to the American people, because whatever is redacted, they're going to point to and say, aha, that's where the smoking gun is. And sure enough, my colleagues on this committee just 5 minutes ago said, aha, that's where important information must be. Well, without a court order, that grand jury testimony is not allowed to be released. That is the law, and we talk about the rule of law. We talk past each other about the rule of law, but the law is the law, and a subpoena is not the law when it comes to grand jury testimony and whether that can be released. The law prohibiting grand jury testimony from being released is the law. So we cannot see the full Mueller report without judicial action. The chairman can go to court and ask the judge to allow disclosure of 6E grand jury testimony. They don't need the administration to join. They want the administration to join. They say, work with us. But has this committee worked with the administration when it comes to the Attorney General appearing before this committee and getting questioned by staff members recently hired onto the committee? No, apparently not. In fact, the chairman hasn't even reviewed the unredacted version that's been provided. I listened with interest as the chairman mentioned in his remarks how important it is that we all read the report. But he hasn't gone down to read the report. This is a charade, and I have never seen anything like it. 225 days progressed from subpoena of Eric Holder to a contempt vote. This circus, 19 days. It's clear that this is just a game for the majority, and now that they have a bad hand, they're bluffing. Give us the unredacted report. Bill Barr is biased. Don't worry about what the law says. The only bias is the blind hatred of this president and disdain for the rules of this House and the rule of law that is in this Constitution. In the views and actions of the majority, the drive for impeachment trumps all. And yes, if it walks like a duck and talks like a duck, it's a duck. So they're trying to impeach the duck.
Said, we will get our power as members of Congress from you, from the American people who vote us in as members of Congress. And then you give us the power to write the laws of this democracy. Then the Constitution says, and the president is there to faithfully execute those laws. And by the way, when the founders framed this Constitution, what they were afraid of is that there would be power concentrated in the hands of very few people or in the hands of one person. And so what they did is they framed the Constitution so that they included checks and balances with 3 co-equal branches of government, at least co-equal. We are Article 1. But at least co-equal. And that was in order for each branch to have jurisdiction and authority over making sure another branch was not abusing their power, not obstructing justice, not using power for their own purpose instead of for the American people. And so now, if we have one branch saying we are not going to respect the authority of a co-equal branch, that puts us in a very, very dangerous position. And why is it that we want these materials? 100% of the materials, not 92%, not just the chairman with one staff member and then he's not allowed to talk about it to anybody else, but everybody. And the chairman has been very generous. He conceded that it would just be the members of the Judiciary Committee and the Intelligence Committees that would look at the full report, not just the unredacted report, but the underlying evidence. Why is that important? Because we need to see everything that was in the report. And frankly, the Attorney General has misrepresented what is in the report. Just look at these articles, the discrepancy between the Mueller report and Barr's summary, how Barr's excerpts compare to the Mueller report's findings. You know why these articles were written? They were written because Attorney General Barr misrepresented what was in the Mueller report. Here are the words of Mr. Mueller himself. Barr's summary letter did not fully capture the context, nature, and substance of this office's work and conclusions. This threatens to undermine a central purpose for which the department appointed the special counsel, to assure full public confidence in the outcome of these investigations. So that is why we must see the full report, so that we can understand exactly what was in it. We can do our constitutional obligations. And I want to be clear that if the president refuses this request, refuses all subpoenas, refuses all witnesses, that affects every aspect of the American people's lives. It means that there is no oversight when the president seeks to strip health care away from millions of Americans. It means there is no oversight when this administration rips children away from their parents at the border. It means there is no oversight over the utilization of public power in the White House for personal gain. At that time, to Senator Grassley using an attorney to question the witnesses? No, they did not. I don't see anyone on record having said that. So, Mr. Chairman, let's be clear. We are at a brink of importance between democracy and dictatorship if we ignore checks and balances. And I fully support holding this Attorney General in contempt for refusing to comply with constitutional foundations. Thank you, Mr. Chairman. I yield back.
Gentlelady yields back. For what purpose does the gentleman from Florida seek recognition?
I have an amendment at the desk, Mr. Chairman.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives find William P. Barr, Attorney General, U.S. Department of Justice, in contempt of Congress for refusal to comply with the subpoena duly issued by the Committee on the Judiciary, offered by Mr. Gates of Florida.
Provision should be construed. Yeah, fine. You will.
After the last paragraph on page 27, insert the following. Rule of construction, no provision in the resolution.
Without objection, the amendment is considered as read. Gentleman is recognized.
Thank you, Mr. Chairman. Earlier today, the gentlelady from Pennsylvania, the vice chair of the committee, said, and I quote, "Nobody is asking the Attorney General to break the law. Nobody is asking the Attorney General to break the law," close quote. And so that comment inspired me to write this amendment, to test the sincerity of that reflection by the leadership of the committee on the majority side. My amendment merely says that no element of the resolution or the report that's currently before the committee would be construed to require the Attorney General of the United States to break any law or break any rule of federal criminal procedure, expressly including but not limited to the rule that has the force of law that says that the Attorney General is not able to provide specific grand jury testimony. And so my hope is that my colleagues were in fact sincere, that this isn't about putting the Attorney General in a catch-22, but I fear that may not be the case. Here's why. If the chairman wanted to, he would be able to go and read the remaining 8% of the Mueller report and in fact take notes on it and potentially even share his thoughts, impressions, conclusions on the House floor. We, in fact, have seen circumstances where the ranking member, in an effort to facilitate greater context and understanding and transparency about the work of this committee over the last 2 years, has, in fact, gone to the floor, utilizing the privileges of the House to release transcripts and testimony that shed light on the true origins of this investigation, the true bias that infected the senior levels of the Department of Justice and the FBI. And so if that was what this was really about, my friend from Maryland, my friend from Washington both said, well, 8%, that could be the whole deal. That could be as significant as the freedom of speech and the freedom of press. I mean, we could find things in this 8% of the report that fundamentally reshape our understanding of the Mueller probe. If that's the case, then just do it. Go tell us what's in it. You have the ability to go read it, come back and share with the rest of the Congress and the rest of the country.
Would the gentleman yield?
Well, since my microphone was cut off last week, I'm going to try to use it all of this week when I have the time, so I'm not going to yield. I do think, though, that as we've heard our colleagues wax poetic about the rule of law, it's important to highlight some of their statements. My friend from Rhode Island said, the rule of law questions are deadly serious. deadly, like life or death, these rule of law questions. And so if we are holding up the rule of law as this great virtue, why then would we ask the Attorney General to break the law in order to serve the rule of law? My friend from Washington said this is one of the greatest tests of the committee. This tests our muster and our merit to see whether we will continue this pursuit of the truth. It is my expectation that this is in fact on purpose. That what the majority has tried to do is put the Attorney General in a situation where they can generate conflict. And they need that conflict because they have a narrative of impeachment that currently binds their caucus. I mean, look, with the Democratic Party right now, you got a fundamental problem. You got one group of people who control the levers of power, the Speaker Pelosi's, and the senior leadership of the Democratic Party. And then you got this whole other batch of people who really control the energy of the party that are on this fast march to a factless impeachment. And so they have to go and generate these little skirmishes to keep the hamsters on the hamster wheel so their more rambunctious members won't rush to the floor in search of impeachment. And it's just, let's just be honest that that's why we're doing this. Let's be honest about the fact that you are using the Attorney General of the United States as a whipping boy because you can't go after a popular president who's got a humming economy, who has seen his approval rating rise since the release of the Mueller report. So do us all a favor. Do the rule of law a favor. Provide substantive legislation that reflects on the words your own committee leadership has used in this very meeting. That you will not use this process to impair the rule of law and to ask the Attorney General of the United States to break the law. And if, by the way, if there's nothing in your report or resolution that demands that the Attorney General break the law, vote for it. Vote for my amendment. But you won't, because you know the real purpose of this is to distract the country, create a fictitious conflict, and divide us even further after you were proven to not be telling the truth as a party about the Russian collusion hoax. I think we can do better. I think this amendment clarifies your words, but you won't vote for it because it's not really what you're doing. And I yield back.
Gentleman yields back. I recognize myself for 5 minutes on the amendment. The gentleman's theories about motives and witch hunts and aside, which I don't agree with, obviously, although I do appreciate the gentleman's use of colorful imagery about the hamster and the hamster wheel. It has never been our intention, as we've stated before, to ask the Attorney General to violate the law. We've always intended, and we've made it very clear, that we wanted him to come to court with us to ask for an exemption to Rule 6E. But having said that, the amendment simply restates our intent, and therefore I accept the amendment. I urge my colleagues to support the amendment. Is there any further discussion on the amendment? Hearing none.
Mr. Chairman.
Gentleman from Arizona. For what purpose does the gentleman from Arizona seek recognition?
Move to strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman. I do appreciate that your willingness to support the gentleman from Florida's amendment. I appreciate that. I'm going to also support and vote for that. But I just want to make one thing perfectly clear again, as I iterated before, and it goes to something that the chairman just said, and it gets to the heart of this thing, and that is, if really one were to believe that the underlying contempt citation was issued irrespective of and not designed to put Mr. Barr into a box where he's got a binary choice, effectively saying, I'll either violate the federal law or I will be held in contempt. I just find it somewhat odd and awkward that he was invited then to go to court and appeal to the court and say, give me permission to reveal this redacted information pursuant to Rule 6E. I mean, I just think that's really interesting, because nobody would really say we need to go to court if you didn't believe that you didn't have authority. And that's, so it's obvious to me that maybe people don't believe they have the authority. They feel they need to go to court. And so I think this amendment, and I'm glad the chairman supports it, because I think this amendment clarifies that it's not the intention of this committee, and nor does Mr. Barr, is he obligated to violate the federal rules. And so, with that,
Will the gentleman
Mr.
yield?
Chairman, I'll yield back. I'll yield back my time.
Gentleman yields back. For what purposes? Gentlelady from California seek recognition.
To strike the last word.
Gentlelady is recognized.
One of the great principles of legislating is to accept a win. So I'm hoping that we can agree to this and go on to what other further discussions we may have. I would just like to say that, you know, as I listened to the debate and I've listened carefully, the concept that it would be reasonable for Mr. Collins and Mr. Nadler to be the only one among our members to review this material is astonishing to me. For example, Mr. Sensenbrenner has been a member of Congress since 1979. That he would not have something to offer if he reviewed this is just not correct. I've been a member of this committee since 1995. I would have something, I think, to offer if I were to review this. So I hope that we can get past the idea that what's been accepted, proposed by the department and then withdrawn is an acceptable outcome. And I would yield to the chairman of the committee.
I thank the gentlelady for yielding. I just want to comment on what was said a moment ago by Mr. Buck. As I said, Biggs, I'm sorry, but Mr. Biggs. As I've said repeatedly, and as the record will bear out, the subpoena was never intended to cover Rule 6E. It has always been made clear that we understand that it is unlawful to get grand jury information without permission of the court. That's why we have asked the Attorney General to join us in petitioning the court to get that grand jury material. We are disappointed that the Attorney General is not doing that, has declined to do that for reasons he won't state. But the contempt citation is for his ignoring the subpoena, in effect. It was never intended to give him to put him in jeopardy by saying you have to give us 6E material. This amendment makes that crystal clear, and we're perfectly happy to accept it since that was always our intent. And there's certainly no contradiction between saying you have to obey a subpoena which is not intended to include 6E material, but by the way, let's ask for the 6E material separately, ask for a court. So I hope that clarifies things, and I urge a yes vote on the amendment. I yield back.
Mr. Chair.
Mr. Chairman.
The gentleman from, what purpose is the gentleman from Georgia seek recognition?
Move to strike last word.
Gentleman is recognized. Gentleman is recognized.
Thank you, and I'm glad that the chairman is accepting this, but let's also be clear that this motion is also for the report and for this contempt area that we're asking to now. We actually offered an amendment during the subpoena, which you just referenced very eloquently. You said it didn't require 6E in your subpoena. However, when we offered an amendment to exclude 6E, we voted for that amendment. Y'all rejected that amendment. So it's interesting that it may not, if you're saying now it doesn't include 6E information, but when we specifically offered an amendment to the subpoena that excluded 6E, we voted for that amendment. You rejected that amendment. There's a contradiction in terms. I'm glad we're accepting this. I'm not going to belabor the point. There's other things that we can talk about, as we go forward. But I will yield to the gentleman from Colorado.
I thank the gentleman for yielding, and I also appreciate the chairman accepting this amendment. I am confused, though, and legitimately confused. I'm not trying to make a political point here. My understanding is that the Attorney General's report has redacted classified information, grand jury material, and ongoing investigations. I'm confused at what we are arguing about if we're not arguing about grand jury material.
Would the gentleman yield?
Yeah, absolutely.
We're arguing about there were 4 categories of material that the Attorney General tells us were redacted. Grand jury material, which we're not concerned with here, as this amendment makes clear. What else? You just mentioned 2 of them. Things that impact other criminal investigations, things that may cast aspersions on third-party reputations, and what was the third?
Classified information.
And, of course, classified information. Plus, of course, all the underlying material. So we're talking about those 3 categories of material, not including the grand jury material, the other 3, plus the underlying evidence and materials for the report itself. That's what we're talking about. That's what we've always been talking about.
Reclaiming my time, we have access to classified material in a SCIF.
No, we have not been accorded that. That's part of the request. It's part of the subpoena, I should say.
May I yield to the gentleman from Georgia, please? Yield
Reclaiming my time. We've just hit on something. This is exactly why we're too far in this process. And I appreciate the chairman bringing out that was a very enlightening discussion here, because that is the part of working with the DOJ on accommodations. That is exactly what we should be doing here, not rushing to contempt. And I think this is, again, I'll go back to my original point, the 6E information. If it wasn't a part of the subpoena, then why reject an amendment that actually said that? And I think that's the curiosity. But I appreciate the chairman, and this is not a criticism, and I agree with my friend from Colorado. This is not a criticism, but this is exactly why, again, for those of us who've been here a while, this is why this contempt is too quick. You can get to attempt at some point.
The gentleman yield?
I'll yield, yes.
We attempted to negotiate, I thank the gentleman for yielding. We attempted to negotiate with the Department of Justice for what, 2 months? Yes. For 2 months, and they refused to talk to us. They finally, and they refused to talk.
And reclaiming my time, and I think reclaiming the time here, you're exactly right, but even 2 months ago, we were just at the very beginning of a report that just came out. And again, this has been talked about all along, but I think this is a healthy debate right here on exactly what we're talking about. I think the reason that we're concerned, and I'm concerned, and many of us are concerned about the actual move to contempt here, is 2 months when looked at in the prism of just the last little bit in this Congress, in the previous Congresses, the timing here is what we're talking about. And it's been said earlier, and I didn't say this earlier from when some of the been comments on the other side that said that when we get to court, when you go to court on a contempt, a civil contempt, especially like this, is that the judge will look at what accommodations and what process has been made. If we have cases in direct discussion here in which over 400 days were used, 300, these are the kind of things.
Gentleman yield for 1 sentence.
I'm at this point need to yield back. I want to yield back to Mr. Buck for a second.
Would the gentleman yield for?
He said I'm yielding to Mr.
Would the gentleman yield?
I
for
only
1
have 50
sentence?
more seconds.
I thank you. I would simply point out that 2 months of refusal to talk to us or to negotiate is not trivial. I yield back.
And Mr. Chairman, I'll take back my time. I'm not saying it's trivial, but it's not nothing. It's not enough either. And I think that's where our terminology is getting. And again, Mr. Chairman, you yourself were very critical of holding Mr. Holder in contempt. Very critical of him being held in contempt. And that was a process that lasted a long time. And my time's over, and I yield back.
Mr. Chairman, I just have a few more questions, if I may, Mr. Chairman, in good faith. Move to strike the last word.
Seek recognition.
I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I am wondering what prevents the committee attorneys from going to court and asking the court to disclose grand jury material. We could ask for that waiver ourselves. We don't need the Attorney General's permission.
Gentleman yield for an answer?
Yeah, I would yield.
Nothing. We intend to do exactly that, but the application is greatly strengthened if it is supported by the Attorney General as opposed to the Attorney General either opposing it, which we don't know he would do. In every previous case where the committee has gone to court and asked for 6E material, the Attorney General has supported that request. What is new is that he has said he would not support the request, and he's given no reason for that.
And Mr. Chairman, reclaiming my time, I believe that in every single case, at least the ones that you have cited in the past, there was an ongoing impeachment proceeding or a select committee that had been impaneled to hear those issues.
Would the gentleman yield?
Yes.
No, that's not correct. For instance, Ken Starr, the special prosecutor, went to the grand jury for grand jury material, went to the court rather for grand jury material well before there was an impeachment inquiry.
And in that situation, we were operating under a different set of rules. There had been a law passed by Congress.
Also, I should add, also in the question of Judge Hastings' impeachment. Well, and let me just say what you just said. Yes, we're operating on a different set of rules, but they do not. But the initial grant of power for the special prosecutor and the special counsel differs, and some other things differ too. But they don't differ in any respect in any way with respect to the ability to get information, or with the ability to seek the Attorney General's assistance in going to court to get grand jury information.
But the law that was passed for the independent counsel statute specifically granted Congress the ability to get grand jury material. The regulation.
No, that's incorrect. I'm told that's not true.
Okay. The regulation.
It granted it at the discretion of the court.
Okay. All right. I just would recommend and ask that if this that we hold a vote that this committee authorize the staff to go to the court and ask for grand jury material.
Well, we certainly intend to do that. I don't know if we need a vote of the committee to do so. If we do, we'll hold such a vote.
Okay. I think that resolves at least a portion of the.
I don't know that it's a question. We certainly intend to do that.
Okay. I yield back.
Claim of executive privilege by the President over the entirety of the materials sought by this committee's lawful subpoena. This is a development that just occurred this morning. It is regrettable that this unfounded claim interrupted negotiations that had finally begun after the committee's many requests. The Attorney General and the Department of Justice ignored our repeated attempts at accommodation and compromise for well over a month. Only in the face of a contempt resolution did the Department begin to engage in a discussion of accommodation without producing a single page of the underlying evidence or materials. When that effort failed, the Attorney General took the extraordinary step of asking the President to assert executive privilege in order to conceal the entire special counsel report and all the evidence and materials underlying it. There is no legal right to stonewall or to obstruct legitimate oversight. That is what we have been seeing as a result of the President's declaration that he is, quote, fighting all the subpoenas, unquote, issued by Congress. The Attorney General may believe that he is merely following orders and seeking to prevent Congress from carrying out its constitutional responsibilities. But history has shown time and again that the first line of defense against undemocratic rule is for those individuals asked to carry out indefensible orders to show the courage, independence, and belief in the institutions under attack to just say no, as the President's former counsel, Don McGahn, did on a number of occasions. We are disappointed that the Attorney General has again shown with his actions today that he is not that person. He has left this committee no choice but to reject the baseless, improper, and indefensible blanket assertion of executive privilege and pass this resolution holding him in contempt. I am proud we are taking this action in defense of our great nation's constitutional system of checks and balances, which, make no mistake, is clearly under attack. I am proud of this committee for standing up in defense of our democratic institutions and principles that we hold so dear. I yield back the balance of my time. Who seeks recognition?
I do, Mr. Chairman.
For what purpose does the gentleman seek recognition?
I seek recognition to oppose this amendment.
Gentleman will.
Try the last word.
Recognized.
Thank you. I think we're interesting now going into this and then trying to come up with something that, let's just go back, on some grounded points here. Executive privilege is grounded in the Constitution, for the privileges and waivers must be intentional. What we're trying to do and arguing through your amendment here is argue the executive branch talking to the executive branch is somehow a waiver of executive privilege. Chairman, you say that because the report is public, executive privilege has been waived. You rely on the Espy case referred to as in re sealed case. The court that had executive privilege waivers must be intentional. In the Espy case, the White House counsel's office conducted an investigation and made the resulting report public. In fact, the court said since executive privilege exists to aid the governmental decision-making process, a waiver should not be lightly inferred. The court refused to take an all-or-nothing approach to executive privilege. Quoting from the very decision that you're relying upon for this motion, the courts have said that the release of a document only waives the privileges for the document or information specifically released, but not for related materials. Here, all the underlying materials not made public are privileged. This is a balancing test where a crime has occurred in the Nixon case. Here, there is no crime that has occurred in the Mueller, as the Mueller report demonstrated. In Ray Sealed case, the court also said the privilege should not extend to the staff outside the White House and executive branch agencies. Instead, the privilege should apply only to the communications authored or solicited and received by those of the immediate White House advisor staff who have broad and significant responsibilities for investigating and formulating the advice to be given to the President on a particular matter which the communications relate. This is an interesting point and should be pointed out because actually the when we had our markup, and the subpoenas that were issued were to Annie Donaldson, Don McGahn, Steve Bannon, Hope Hicks, Reince Priebus, the highest-ranking officials in this, some of the highest-ranking in this White House, and the very people the court held that should have executive privilege. And when we look at this in the underlying report, even in the Mueller report, just getting around it because we don't like it through an amendment is not getting around this. And I think when coupled with the fact that we have had discussions here of rushing to this, not having an accommodation process, not talking, and many times, as you well know, and folks who have been here a while, it does take what I'll call, you know, those termination points, those pinch points. There's not an impasse here. And I think that's the interesting part about this. And it's always talked about in contempt is what is the impasse? There is no impasse here because there's at least still negotiations, even from what the Department of Justice offered yesterday to say if we go to this step, we'll be back next week and we'll discuss some more. There is an impasse. Now, maybe there's the discussion that didn't like it because this was actually, you know, the same thing was done by President Obama in the Eric Holder case, but actually not for those closest to the president himself, but for actually lesser officials. So in looking at this is not new in the exertion of the executive privilege. The case that you're relying upon, even in the most generous reading, is a 50-50 toss-up for what you're trying to do here with this, and that's at the most generous of reading. At a sort of what I would say is a factual reading in it, it's not 50-50. It says that this is actually held. So as we go down this line, I understand the chairman's frustrations. I disagree with the chairman's frustrations on the fact that you're not getting the information that you want, or you're at this point not getting it in the way you want it. But it has been pointed out that you have the ability to go to court to try and make this happen. Also, before I quit here, the Starr case is not precedent, and we keep bringing this up. The Starr case is not precedent. One, the statute is defunct, and also today we have what is the Clinton-era Special Counsel Investigation Regulations, which is what Bill Barr is actually operating under. So if we want to go back and discuss, again, non-applicable precedent here, that is something issue because the Starr report was actually made for the purpose of giving recommendations for impeachment. That's not what has happened under the special counsel's advice here, and was not why the Mueller report was actually done. So if we count this case from a strictly legal reading, again, at best, it's a 50-50 jump ball to say that this is actually for this. But if you actually get into it, and especially what your subpoenas asked for, those closest to the president, this case actually sides and leans more toward what my argument that this case does not apply and that your amendment is not, should not be well taken and should be voted down. We have a lot left to go here. There's more problems with this than just the executive privilege issue that has been listed here. There is the problem of once you get before a judge and saying, what did you actually do to ask and get to this? There's no accommodations been made. This is, again, a process and a rush to judgment. I would encourage all members to read the case, read the underlying case that this is based on, and reject this motion as it is offered. And with that, I yield back.
Thank the gentleman. Having used far less than my allotted 5 minutes, and having just realized that in the haste with which we prepared this, I neglected to actually describe what the amendment actually does, I yield myself 15 seconds for that purpose. The amendment supplements the contempt report to address the Attorney General's statement last night and letter this morning that he is asserting executive privilege over the redacted portions of the report and all underlying materials. The amendment then explains some of the many reasons why we believe that assertion of privilege lacks any valid basis. I yield back. Who seeks recognition? Then we'll take the vote on. The gentlelady from Pennsylvania is recognized. For what purpose does the gentlelady from Pennsylvania seek recognition? Gentlelady is recognized.
Thank you, Mr. Chairman, and thank you for offering this amendment, which I support. I was puzzled, maybe like many of you, that we received this morning, I received it here in hand at about 10 o'clock this morning, a letter dated today, May the 8th, 2019, addressed to the President, the White House, Washington, D.C. Dear Mr. President, I am writing to request that you make a proactive assertion of executive privilege with respect to the Department of Justice documents recently subpoenaed by the Committee on Judiciary of the House of Representatives that is signed by William Barr, Attorney General, not personal attorney to the President, Attorney General Barr. And I contrast that with something I was taking a look at dated January 29th of last year, 2018, written by personal attorney for the president, John Dowd, to Robert Mueller in response to Robert Mueller asking for the president to come on in and testify, to interview with the president and discuss concerns regarding the report and the investigation. There's a list of some 15 areas of concern that the special counsel asked for the president to come on in and discuss. And guess what his personal attorney, John Dowd, said during this long letter? After reviewing the list of topics you presented, it is abundantly clear to the undersigned that all of the answers to your inquiries are contained in the exhibits and testimony that have already been voluntarily provided to you by the White House and witnesses, all of which clearly show there was no collusion with Russia and that no FBI investigation even could have been obstructed. Farther down in the letter, we all remain in agreement that your office has received unprecedented access and voluntary cooperation in the collection of all documents requested by the White House.